Please, Lordship. My Lord, item 8.
Huh?
Item 8 of today's list, my Lord. My Lord, I have some difficulty. It may kindly be listed after 2 weeks. And my Lord, I have another prayer. This is a habeas corpus petition. A major girl has been kept captive. And the case was first listed before division bench. Then it was felt that it will be before the single judge. And the learned single judge passed some effective order. The case was listed yesterday. Then again said that it is a matter of division bench. So, my Lord, I am mentioning this may kindly, this matter may be listed tomorrow, my.
So tomorrow it may not be possible because it will administratively water will be required. I'll get it listed on Monday. You give the details. If possible, tomorrow you give the details.
Well, right, okay.
Give the details right away.
May it please your
Is
lordship.
it a fresh matter?
My Lord,
Is it a fresh matter?
fresh matter, yes, ma'am.
Then you give the details. Give the details.
Yes, in the mention, I will write it a fresh matter and
You just give the number.
it is already numbered, my Lord.
Then you give the details. That is what I'm saying. It will be
Right.
listed tomorrow.
Yes.
May it please your lordships. Lordships, I beg to mention an item for listing either tomorrow or Monday, lordships. This is an urgent matter pertaining to the Sikkim case, lordships. In that, though there is no stay, our petitioners are deprived from participating in state government jobs which are advertised, lordships. And the date is 15th is the last date. So we pray for an indulgence, lordships. It may be.
Is it a fresh matter?
It is an interlocutory application in the writ appeal, lordship, which is pending.
You have filed IA.
Yes, lordship.
Let it come.
Monday, lordship.
Next.
Lordships, the 15th is the last date, lordship. Maybe accommodate.
May I please, your lordship, with due permission from the other side, lordship, I beg to mention for item number 11 of today's list, lordship, I have to receive instructions from the deputy authority, lordship. Lordship, kindly pass over for 2 weeks, lordship.
You have to file affidavit, madam.
Yes, lordship, you have to receive instruction, lordship. I have
This is
taken
the last
caution.
chance. Next.
Deep level.
May please your lordship, with the consent of the other side, I beg to mention item number 32. My senior has some difficulties today, so please take the matter after.
Lordship,
One
I have
week.
an objection, Lordship. They are taking time repeatedly, Lordship. And the college is suffering as well as the students are suffering for no appointment of the.
Next.
Let it be come up next week, Lordship, as a last chance, Lordship.
Next.
May I please,
We'll give some date.
I'd like to mention item number 22, 23, and 24.
Yes.
And this council is after, lordship, can it be fixed after 25th November, lordship?
12 December. 12 December.
May I appeal,
12
Lordship?
December.
May I appeal, Lordship? With the consent of the other side, Lordship, I beg to mention item number 9, Lordship. But can this matter may be adjourned for 2 weeks, Lordship? I have taken a consent of the other side.
Why do you need time in that?
Lordship, we have some difficulties, Lordship, today. My senior has not
Next
come.
week.
With the offer.
Mention for the urgent listing, my lord. This application pertain to the surface action, my lord. Since the DRT is not available till 24th of this month, so we are actually remedialess so that we have filed this application, fresh application before this honorable court
Monday.
on the.
Monday.
Can it be tomorrow, my lord? Because
No. Surface there is never urgent.
okay, ma'am.
May I please, your
Urgency
lordship?
starts when the client approaches your office.
But my lord, just my lord. On Monday, ma'am.
May I please, your lordship?
Deep level.
I beg to mention item number 29 for orders, your lordship. I have heard the respondent number 7 to 15, your lordship. And I am seeking for time to file affidavit, your lordship, due to some development, new development, your lordship. With the consent of other side, your lordship.
IR to continue. Next. IR is there, that will continue. Next.
Deep level.
May I please your lordships, I'd like to mention item number 26 for requisition of affidavit which was filed yesterday to be tagged along with the case report.
We'll call for it. Call for the affidavit.
May I please, your lordship, I beg to item number 1, lordship,
In this case, Lordship, the senior counsel, Mr. Priyan Chaudhary will be led this case, Lordship. And Lordship, he could not prepare as because Lordship, we could not communicate the petitioner, Lordship. There is a communication gap. That is why Lordship can it be fixed on in the last week of this month, Lordship.
Last week of
This month, if possible.
21st.
Obliged.
May I please, Lordship? With consent of these other parties, I beg to mention item number 34 and 35, my lord. Y.S. Manan, he has developed some pain, so today he cannot come. So next week or after 1 week, any date, my lord?
Let it be after a week.
So whenever you want.
25.
Item number?
34 and 35, your lord.
Yes.
May it please, your Lordship.
President, Lordship. Mr. I beg to mention item number 5, Lordship. Mr. Yukana, senior counsel is not keeping well and is not attending the court today, Lordship. Item number, Lordship, I have a similar prayer for item number 7, Lordship. Can it be taken up after 2 weeks?
2 weeks.
2 weeks, Lordship.
Yes.
Pleasure.
May it please, your Lordship. Lordship, with the consent of the other side, I beg to mention item 17, Lordship.
17.
17, Lordship. Lordship, may be pleased to fix it in the last week of November, Lordship.
So we'll say that it will go to the hearing list.
Lordship,
Readings are
Lordship,
complete.
Lordship, pleadings are complete. Deeply. Okay.
You are mentioning only one matter?
Lordship, only item 17. Lordship.
That is why we are telling, you are mentioning only one matter. There is one more matter which you may be required to mention.
Lordship,
No problem. Some
Lordship,
AOR may be different. Call out.
Item number 2 of daily list for motion.
May please, your lordship. May pay for a week's time to file counter to the additional affidavit filed by the respondent bank, your lordship.
What counter is there? These are documents.
Additional affidavit, your lordship. They have
No.
filed.
Additional documents are brought on record. What counter has to be there?
Lordship, actually, by the sale deed, your lordship, the petitioner has purchased a roof on the first floor, your lordship. That means the possession of the petitioner is on the second floor, your lordship. And bank has already taken possession of the ground floor and first floor, your lordship.
We are not concerned with it. It's a surfacey matter, lordship. We are not going to entertain further after in view of this affidavit now. Go to TRT and get it settled. Your rights if you have any. There has to be a limit. Don't convert us to as tribunals. Anyway, if you want time, we may grant you time. Don't say no to anybody. Otherwise, don't unnecessarily buy time. 16.
Oh, pleasure.
Item number 3.
May I please, my lord? My lord, I pray for pass over the matter for today, my lord.
Pass over 2 o'clock.
Oblige me. Item number 4.
Lordship, this matter relates to that postal recovery matter. Lordship, I am seeking some more time. I am yet to receive extra. Yes.
At 99,000.
That is what, Lordship.
Next week or you want 2 weeks?
Lordship, if it is not inconvenient, Lordship, can it be after 2nd? In between, I will not be there.
2nd of?
2nd of December, Lord.
5th December.
Lordship.
Item number 6.
May it please, your lordship. Lordship, this is a habeas corpus application, my lord. The detainees, they were initially declared as foreigners by the foreigners.
Now look at your prayer grateful. Now, it is a division bench matter because it's a habeas.
No, no.
Now, they are declared to be under detention.
Yes.
Now, therefore, it is not the question that they are in illegal detention. If you want to challenge the orders passed by foreign tribunal act, go before the appropriate bench.
No, my lord, we initially challenged the order before
It has gone up to apex court and it is dismissed.
dismissed for default, my lord.
That we are not here to advise you.
No, no, my lord, but then there was a judgment from the order from the Honorable Apex Court that detainees who have spent more than 3 years in detention camps and that they are awaiting deportation, they are to be released on bail, my lord. They have annexed that order, my lord.
That all order we have seen, then,
Yes, ma'am.
then it is not a habeas corpus petition.
Well, then we were released, my lord. We were released, we came out. Subsequently, we were again arrested when again kept put in the detention.
That is
camp.
why there is no question of habeas. It may be a petition under the Foreign Tribunal Act. Go before appropriate bench. This is bench would change by way of your prayer that you have prayed for. That is
we
where
are-
the objection lies.
My lords, we are pleading that the detention itself is illegal since we were once released on bail and
No,
we
no,
have
there-
not defied any of the conditions of bail, my lord.
Therefore, you approach appropriate forum. Otherwise, their affidavit is very clear. And you have lost up to apex court.
My lord, in the Apex Court, it was only dismissed for default with a
Only means what, Mr. Counsel? Only means what? You have not pursued it. You are a seasoned counsel, sir. On the contrary, division bench order is against you. We can't take a different view, sir. If we go on technical ground, even this hearing may not be possible to be given to you. Earlier division bench order is there. You challenge it unsuccessfully. I repeat your words that it
Yes,
is
ma'am.
dismissed for default, but it is dismissed.
My lord.
Therefore, the whatever may be, may not be on merit, but the order of the earlier division coordinate bench stands as it is.
Yes, my lord.
We can't take a different view. If you are aggrieved by their action under the Foreign Act, file appropriate petition before the appropriate bench. Here the jurisdiction changes by way of the prayer under Act 890. Where is the question of appeal? They have declared that they are under detention. And this is not that detention order as we understand.
No.
In common parlance, say under NDPS Act, there are 1 or 2 matters on the today's court itself. Understand, Mr. Counsel?
Yes, ma'am.
So you can take all remedies that are available. You say that any government made in the affidavit also shall not affect your right because you are not pressing this petition to take appropriate steps. Heard, Mr. Sarfaraz Nawaz.
Yes, my lord.
I hope you are not a cricketer.
No, ma'am. We used to play, but not anymore, my lord.
You have the name of a
Yes, my lord.
prominent bowler of those days. Our age rather, not your age. Mr. R.K.T. Chaudhary, run a deputy solicitor general for this one number 1 and D. Nath for this one number 227. Mr. Sarfaraz Nawaz, run counsel appearing to the petitioner, does not press this petition with the liberty to take appropriate proceeding to challenge the action taken by the respondents under Foreigner Act. With this liberty, the petition is disposed of. Any observations made in this order as well as given in the affidavit in reply filed by respondent numbers 227 in this petition shall not affect the rights of the petitioner.
Deeply obliged, ma'am.
Next.
Matter number 10,
May I please, Lordship? My lord,
Yes, sir.
may I please, Lordship? My lord, in this case, my lord, petitioners, my lord, father, my lord, died in harness, my lord.
When?
My lord, 2000, my lord.
Do you have the date or only year is there?
My lord, 2000, my lord, 25/12/2000, my lord, and he applied immediately thereafter, my lord, on 4/9/2001, my lord. But taking, my lord, his wrong date of, my lord, application, my lord, his claim was rejected, my lord.
Now, when did you challenge that rejection?
Rejection, my lord, it was sometime, my lord, late, my lord. But this late was because of, my lord, departmental, my lord, mistake.
Sir, you try to answer what we are asking.
Yes, my lord. It was, my lord, only, my lord,
Mr.
challenge.
Counsel, we may tell you, we know when you challenge. We are asking you because we want date from you.
Yes, my lord.
Let us be very clear. So don't try to play hide and seek. On fact,
2022, my lord.
22.
Yes, sir.
Now you go through this judgment of the Supreme Court. 2022 live law Supreme Court 819. उनको कॉपी दीजिए. Give him a copy. Please go through this. This is the latest one.
My lord.
And come on Monday.
My lord.
Next.
Deep number.
Item number 12.
Yes, Majmudar.
May I please, your lordship?
Don't run.
My lord, I was thinking this again. My lord, the matter is pending at the government level, waiting for the WPT and BC department to give their approval on the roster points, my lord. So it may take some time, my lord. Once we receive it from there, the director's office says that it can be, the promotions can be easily handled.
22nd.
Lordship, instead of, lordship,
Let them
submitting,
come out. They are trying to resolve the issue. Wait for. We are only granting him 10 days, practically.
Oblige.
Item number 13.
State was asked to file, my lord, the counter, my lord, affidavit.
Yes, Mr. Majmudar.
My lord, small accommodation, my lord, about a week's time we'll file the affidavit. Mockwell. Yeah. Right.
Otherwise, they are on bail in other offense.
My lord.
They are on bail in other offense.
In other cases, I am on bail. Okay.
File affidavit.
My lord, file.
Because your affidavit is there before the learned single judge, but it is
Can it be fixed on 29th, my lord?
20.
My-
Can you give us the affidavit in?
My-
Mr. Nath, if you can give it earlier so that on 29. Next.
Item number 14.
May it please your lordship. But we have filed this appeal being agreed by the order dated 21/9/2022, passed by the learned single judge, my lord, where my lord learned single judge fixed the date and directed the DC to hold a meeting, my lord.
So it's a consent order. It's a consent order.
My lord, we agree that there was an agreement, my lord, but that
Then you
agreement,
file a review before the learned single judge.
my lord, but that agreement should not be at the expense of the mandatory provision of section 15, my lord.
Yes, sir. But then at your count, you appeared or has anybody else appeared?
Lordship, we only appeared.
Huh?
My lord, we only appeared, man.
Then wisdom done after the order was passed. And then you are saying that the learned single judge has committed an error. Go and ask the learned single judge that we had wrongly, now we have wisdom has done and we don't want to stick to our agreement. You make learned single judge pass a particular order which is within the realm of four corners of law, and then you say that it is wrong. You may be correct.
My lord, at least, my lord,
At least
the
what
mandatory
you-
provision of
courtesy
15
should be shown to the learned single judge. At least, you are absolutely correct. This crossing of lobby from left to right will not give jurisdiction in every case. And don't forget that jurisdiction is a discretionary relief. Come, who is Mr. Datta?
Lords, I'm representing PNRD today.
No, who is Mr. Datta?
He was the counsel who represented PNRD before the single judgment.
And P. Das and P. Chaudhary? You are Mr. P. Das?
Okay.
All have agreed. Now you want to turn table. Go before the learned single judge. It appears from the very bare reading of the observations made by the learned single judge that the learned counsels appearing for all the parties agreed before the learned single judge for a particular course, and now they cannot be permitted to raise issues before the division bench and say that there was no agreement. The appropriate remedy, in our opinion, would be to file a review application before the learned single judge. The appeal is therefore disposed of. The liberty to file appropriate review before the learned single judge. Appeal stands disposed of. Next.
Much of. Item number 15.
Await service. As always. Next.
Item number 16.
May I please, your lordship, by tomorrow we will file the affidavit, your lordship. Only one short accommodation.
2 weeks. Next. Next. That will also go. Here pleadings are complete.
My lord.
Pleadings are complete.
My lord, leading sir, this is that my lord, the forest protection post constable appointment date. My respected friend was supposed to obtain instruction
Instructions.
regarding the rules and my lord, the last part.
Lordship, the rules, your lordship, have not been framed. It is done as per the earlier Assam Forest Manual, your lordship. No new rules, service rules are there. As per the Assam Forest Manual, it is being completed.
We'll fix the matter for hearing.
My lord, my lord.
Pleadings are complete to be admitted for hearing, to be listed in the hearing list. Next.
Obligation.
May it pleases your lordship. We have filed our affidavit, your lordship. Thus, the service completed. Regarding to that, your lordship, affidavit was filed today.
When have you filed the affidavit?
Your lordship, today it's early morning.
Then you wait for the other side to appear.
Yes, your lordship.
Let them appear. Ms. P. Das and counsel appearing for Mr. S. Kyle said that the justice service is affected upon the respondent. However, the affidavit has been filed today, and in the interest of justice, to enable the respondent to file their appearance public appear before this court. Adjourned to 28th of November.
Deeply
Next.
obliged.
There was one more matter at item number 15 where you are supposed to take steps. It is your office matter. Nobody was there. Item number 15, please check up the board.
Yes, sir.
Next. Or it may be Mr. Chaudhary's matter also, we don't know.
My lord, in the case, my lord, we have received an affidavit, my lord. But there are three of the affidavit at page 125, my lord. It seems, my lord, process of constitution of the Assam groundwater authority is underway as per the provision of the act and rule, my lord.
Now
It is-
rules have come up.
Rules have come out. They have been placed before the assembly as per the requirement of the act, your lordship. And now the process of constitution of the body is underway.
I think some report was there in yesterday's newspaper also.
Yes, your lord, perhaps. Yes.
I had cursorily in those.
So otherwise, the prayers which have been made in the PI,
They are now, but
Now-
we intend to observe that it will be placed in the assembly at the earliest.
it has already been placed. Your lord.
It is, my lord, under process, man, as per the contention
Therefore,
of
we'll say
the.
that it may be placed in the next session.
No, the rules have been placed before the assembly, already placed. Your lord.
Therefore, somebody will have to consider it. Placing may take 10 years.
Lordship, otherwise, the requirement, your lordship, was there was no requirement for approval from the assembly. The act said that after the act, rules are
It has to
framed,
be placed before
it is
the,
placed. Now, in fact, after that, after placing,
Hmm.
the process of constitution of the body is also underway. As
how-
per the rules.
now how long will it take?
Perhaps maximum, maybe two more months, your lordship, perhaps
So
maximum.
we'll say that it will be constituted latest by 31st
Yes,
of
sir.
January.
Yes, sir. That, yes, sir.
So that see, all prayers can be taken into consideration intact.
Yes, sir.
It has to be
Yes, sir.
implemented, my lord, for the betterment of entire party, my lord. Otherwise, my lord, they will come, it will be like a Bombay, my lord.
No,
What-
therefore, Mr. Counsel, we are going to put a cap of time also. for
Lordship,
that.
lordship,
We'll pass appropriate order.
lordship.
Deeply obliged.
Disposed of.
Deeply obliged.
Lordship, giving a time, my lord, and
31st January
Lordship.
2023.
lordship.
May I please, your lordship? Your lordship, pertaining to item number 15, we are not appearing, your lordship. Earlier, my senior is assistant
It must be
SDS.
Mr. Chaudhary's matter.
Yes, your lordship.
We'll inform him. Thank you.
Yes, your lordship. Deeply obliged.
Yes, Counsel.
My lord. We have filed, my lord, petition, my lord, for, although there is a division bench order, my lord, the husband is not paying the 50% cost of the education of the site. So every year we have to file miscellaneous application, my lord. And in this year, we have also filed a contempt and notice has been issued by the small court. And may, my lord, this matter we tag with contempt, my lord.
To be heard along with the contempt. petition.
Contempt number 289/2022.
Write the number. Next. When is the
Right.
contempt listed?
My lord, last week it was listed, my lord, and the respondent took time, my lord. Contempt number 289/2022.
Adjourn it to the same date.
Obliged.
Yes, Mr. Nath. Do you want to file any reply?
Lord, we have filed our reply, my lord.
No, reply is not on record.
My lord, we have filed, my lord.
Reply is not on record.
It will be taken on next week, my lord. Along with the reply.
When did you file reply?
My lord, we have filed, my lord.
So the last entry is their opposition dated 6/9/2022.
Within reply, filed, my lord. On 4th of November, my lord.
Call for it.
Yes.
The reply filed by the respondent. by the petitioner to the affidavit in opposition filed by the state on 4th November 2022 be placed on record. Section 217, 18.
18.
No, 17, 7.
7. Not
He is in detention.
17. 11.
Probably Mr. Nath. Recently, last week, FF court has taken a view. Here also, it took 93 days for deciding.
For disposal of the representative.
93 days. I have calculated it. Though he has not raised the ground, but it is our duty to point you out. Next,
I'll see them.
take out that judgment.
I'll take.
Next. Hey, affidavit. It is not received.
No, not tag with this record, my lord.
अरे वो रजिस्ट्री में भी नहीं है रजिस्ट्री में you come at 2 o'clock.
My lord. Oblige.
By that time we'll call for the affidavit. Please call for the affidavit before 2 o'clock. Next. Yes, Ms. Bhattacharya.
Lordship, 10 days time is required to file affidavit.
Huh?
10 days time is required to file affidavit.
I will not grant you any time. He is already released. Where is he?
No, Lordship, he was detained in another case, Lordship.
He was released.
Where is Ms. Bhattacharya?
She is not well today, Lordship.
We will not grant time. Somebody else has to appear. Give papers to Mr. Nath. Be ready by 2 o'clock. This matter has already lived his life.
May it please your lordship. May it please your lordship, my lord. So with due apologies, my lord. In this matter, my lord, on the last occasion, Mr. H.K. Das was. Mr. H.K. Das, yes, he was appointed as amicus, my lord. However, my lord, our names are not reflected in the cause list, my lord. We were made aware today, my lord. So, my lord, with apologies, I pray that the matter may be taken up any other day, my lord.
The registry is directed to implement the order dated.
The order dated
19/10/2022 and show name of Mr. H.K. Das and counsel as amicus curiae in the matter. Joint register judicial to do the needful today itself. Petition to 15th of November.
Oblige, lordship.
Next. Service is not affected. Service is not affected.
Lordship, in this case, lordship, the order of the court, election has been conducted and I have been elected, lordship. There is not contested with me. I only one person, that is I am. And service is awaited.
So you don't press this appeal?
No, since service is awaited, lordship. 30% is appeared, lordship.
Service is awaited for rest.
Lordship.
So await service. Let the service be completed.
Awaited, sir.
Next.
This petitioner, my lord, he is not getting a salary. That order passed by your lordship is that if she is working, my lord, her salary should be released. And she is working since 2006. There is a contempt case, my lord, it is recorded there that she is continuing with her job.
We are all. I have received the report, madam. The thing is that here, my lord, London AG will appear, madam. As per the direction of this honorable court,
Last occasion also on the same ground, my lord, time was given, but she is a poor lady, my lord, not getting a salary. Contempt, my lord, they have filed affidavit showing, my lord, that she is working. But the affidavit may kindly be seen, my lord. The order passed by this court in contempt, my lord. The respondent number 3, Director Elementary Education, filed an affidavit in opposition, stating that the petitioner was indeed found to have worked all this time.
We have stayed the earlier order, isn't it?
Well, that is earlier order, the first order, which is less, which is impugned here is that page 119.
But learned advocate general appeared at the first instance also.
On last occasion also, learned advocate general is very fortunate, but my petitioner is not getting salary since 2006. And the order is very clear, if she is working, she is entitled to get salary. And her appointment is also intact.
No, this is appealed by the state.
Yes,
Hello?
This is appealed by the state,
Yes, ma'am.
where we have granted interim relief.
No, your lordship did not give any interim relief.
No, it is granted, sir, in IA. IA we have granted. stay.
For further order.
No, till remain state, then we have extended it also to today.
But your lordship will, while admitting the petition, lordship state will try to dispose it of. God will. It is an urgent matter for the petitioner.
No, we'll see that something is worked out. That was the idea why we state the order.
Well,
Say to continue.
date may be given, she is really suffering because
22nd. Next.
Hopefully, it is,
We don't know. All depends what happens today.
every time, the matter
No,
is.
this is why, Mr. Das, I'm saying it all depends upon what happens today.
Well, that we are. Obliged.
Mediation report, sir. What has happened to the mediation proceeding?
Lord, mediation is failed, my lord.
Failed.
My lord.
So you have not received any report.
My lord.
Oh, okay. LTR is there.
My lord.
And we'll hear you and
My lord.
we'll hear you. LTR is there.
Yes, my lord.
Tell us.
My lord. Appellant is the wife, my lord, and hereby challenge the decree of divorce granted in favor of the respondent husband, my lord. Here, my lord, decree of divorce has been granted on the ground of cruelty and irretrievable breakdown. Here, my lord, the allegation, the contention of the respondent in the suit is that she, after marriage, insisted the respondent husband to live separately and misbehave the husband and the other in-laws, the parents of the my lord husband. And she used to go out. She is a service holder, my lord. She is serving in seated at Sanctuary, which is, my lord, about 20 kilometers away from her matrimonial home. And it is the contention of the respondent, my lord, that she used to
Mr.
live.
Counsel, as the mediation is not
My lord.
on any way out, it appears that it is now no possibility of any other compromise.
My lord.
Staying together, I don't think is
My
possible.
lord.
You are for the husband,
I am for the wife, my lord.
wife. And why don't you separate?
My lord, actually, I had to leave the matrimonial home under a impelling situation, my lord.
No, whatever it may be. Now 10 years have passed. You have a long life.
My lord.
If you can't stay together, separate. What else can be done?
She actually intended to live with her husband, my lord, but he refused to, in the mediation also, he refused to
And
accept.
now it is not possible.
Not possible. That is a fact, ma'am.
Therefore, settle it otherwise. What are you doing in life? My lord, I am also serving, my lord.
Then why do you state it further?
Then my lord, only question of alimony will come.
Naturally.
My lord. That is. Until that we have not claimed alimony to the house.
No, you are serving, so
My lord.
naturally pendant light may not be necessary.
My lord. My lord.
You don't have issue. You don't have any children, child.
Child is there, my lord.
Child is there.
One, my lord. Girl child is there, my lord. Daughter is there, my lord. She is present as at about 10 years. most probably.
He stays with whom? Mother?
My lord.
He stays with mother or
Mother,
father?
my lord.
So you have to look to her, both of you have to look to the future of the child.
My lord. My lord.
Go on fighting for what?
My lord, it is the point, my lord, the father of the child never met her till today, my lord, since her born, my lord. He is paying maintenance to the child, my lord. Respondent is paying. So, my lord, only a question of permanent alimony that is there.
Ultimately, what you sit together and if you are reasonable, it can be resolved.
My lord.
Only thing is that people become unreasonable. And demand a bounty from the husband. That also it has to be evenly balanced. You are serving,
My lord.
but future of the child has to be secured first. You have a government job.
Yes, my lord.
What is he doing, the husband?
My lord.
What is the husband doing?
Husband is also an engineer of railway, my lord.
Okay. Who you appear for the husband?
Yes, ma'am. They've been separated for more than 12 years. Ma'am.
No, that we have seen from the pleading.
Yes,
Therefore, if they can't stay together, they can separate.
Yes.
And resolve the issue. The future of
Date
the
of filing of the FIR, my lord, 498K was filed.
No, now everything can be settled. That is why we send you to mediation.
Yeah, but after 12 years separation, my lord, it is difficult.
I understand, but you can now separate. You are also obstinate, it seems.
Because she didn't file any application for alimony actually in the family court.
Maybe now permanent alimony decide and forget it. We can pass a consent decree. We can send you to the family court on the 13B also.
Yes, he has not filed. Yes, he can file now separate application. Yes.
That is pendant delight.
Yes, Penny we are paying for maintenance for the child.
I am also not claiming the pendant like maintenance. my lord.
You have not filed any pendant
He
delight.
has not claimed
No,
anything.
Therefore, try to
My lord, only
you both of you can take some interest and see that it is resolved.
my lord.
Otherwise, this will continue. We'll admit the appeal and then again for few years you will have to unnecessarily wait for the result of.
My lord.
We don't mind admitting the appeal. If you don't want to go and find out a solution, we can't force you.
I am ready, my lord. On my part, I am ready.
What are your views, Mr. Counsel?
Because on the mediation, my lord, he says that after 12 years,
No, therefore,
and they are not having talking terms, my lord. That's the problem.
therefore, the net result is that you are not able to now stay together.
Yes, yes.
But you can separate. That is what you want. There is a decree in your favor.
And moreover, they have not having good terms for last 12 years. Litigation was there.
That is what we are saying. That now you have got a decree of separation.
Not only decree, 498 case was there, where I was acquitted. Then I filed appeal against 498A.
You forget that.
Yes.
Are you ready to consider permanent alimony? Then we may put an end to this.
Permanent alimony, if she files an application, naturally we can.
No, you can agree here, out of court.
That I have to take instruction, my lord.
That is what we are saying.
Yes, my lord.
If you take real instructions, it can be resolved.
Yes.
If you have some
Otherwise, we will admit the appeal and you wait for your turn. Tell us by 2 weeks. They are local clients from Guwahati itself, I think.
Yeah, local plan. On my part, I am ready for my lord.
So let now staying together, reconciliation is not possible.
Not possible,
So you can separate and decide on permanent alimony.
lord.
What else?
my lord. That will be better, my lord.
The future of the child can be protected properly.
Yes, yes.
And if any other litigation is pending
No,
between
my
both
lord.
of you,
As
then
on
you,
today, no litigation. is there.
that you have to withdraw.
Yes.
Try to resolve it in that manner. Third, learned advocate for the parties to explore further possibility of a compromise adjourned to 29th of November. 29th November.
Yes, okay.
Next. Okay, it is covered. Yes, Majmudar?
The written submissions have been given, my lord. My lord, yes, the grievance of the petitioners is that the graduate teachers are also being given the opportunity to compete for the post of headmasters along with the assistant headmasters. In the 2003 rules, it was the graduate teachers alone, along with those who had requisite experience as assistant headmasters could also participate.
My brother says that this is a covered issue.
It is covered on the last litigation under the 2003 rules. Their challenge was negated. Now under the 18 rules, they made the fresh challenge again. Because now the rules are different, but parameter it will remain the same. The logic remains the same. There is a little bit difference in the rules because on the earlier occasion in the 2003 rules, the assistant headmasters were not specifically included in the Pidakada. That was the grievance. Now the assistant teachers come up to say that graduate teachers should not be there competing with us. But that both should be considered together, that logic would remain the same, my lord. Ultimately, that both should have an opportunity to vie for the post of headmasters. That will remain the same, my lord, the conclusion of the court that had been reached in the earlier occasion. Therefore, the submission that it is covered.
Their grievance of the earlier round of litigation was the seniority part.
Yes, ma'am.
That seniority will be on the basis of who receives the graduate scale earlier.
Yes. But
In
the
that
assistant
context-
headmasters there was not there included in the rules as such. The term assistant headmasters was not there, but because they were
treated
also
as-
graduate teachers were onboarded
they're
and their
treated
seniority
as
was being counted.
Graduate teachers.
Yes. Seniority as graduate teachers was being counted. That was the grievance. Now the grievance is only assistant headmasters should be taken into consideration. All the graduate teachers should be out.
That is answered by the TRIPA.
It is covered.
That-
That is our stand. But on the last occasion, Mr. Saike had said that because now earlier the election was on a school level. Therefore, in the absence of taking into account the graduate teachers, there'd be no selection, only the assistant headmaster would compete. That has now been taken away by making the selection for the post of headmaster on a district level. So there will be competition, was his argument that part of the judgment would not apply. But the other part entirely would apply. Only one of the reasons he is countering. The other reasons he has not touched at all. So therefore, it would completely cover me.
Therefore, you said that it is a covered issue.
It is a covered issue. The rules do not need an interference, is my case.
There is no other ground. What is the ground to challenge to say that only assistant headmasters?
They have taken up two grounds. One, that they are two different cadres. Assistant headmaster and graduate teachers are two
Because
different
they-
cadres, should not be
No,
clubbed together.
because the channel of entry is different.
Not the channel of entry, but both remain graduate teachers till a certain point of time. The senior most teacher in a particular school is designated as the assistant headmaster with a higher scale of pay. Otherwise, it remains the same everything.
Otherwise, basic qualification also are same.
Yes.
It is not like that earlier matter where headmaster and vice headmaster or something was there.
The B.Ed
B.Ed
qualification to be different. No, that was not that. The assistant headmasters here remain without B.Ed also.
Right.
And graduate teachers with B.Ed can also become assistant
So
headmasters.
here
It's
there
not
is,
difficult.
in a way, there is merger.
Yes,
In a way, indirectly, it is merger of cater.
yes. But that is done only for the purpose of promotion to the post of headmaster. We take into consideration the seniority and If Lordship has my written submission, my lord, I have tried to make the difference clear, my lord.
Let us go through your written submission.
My lord.
Let us go through your written submission.
I have put it the paragraphs, relevant paragraphs of the earlier judgment also.
There are 11 and 12. Repass into that.
Repass into that, and also another issue.
Your-
Page 5, the last paragraph, their only ground.
This is your. COVID certificate. Your thing. What you want to- what about-
Let us hear the petitioner.
Yes, my lord, Mr. Ayeshika is arguing, yes, I have two, my lord, to be taken.
At two.
Yes, my lord.
We'll take up at 2 o'clock.
Yes.
Publish.
Next.
May it please your lordship. The impugned judgment is at page 147. Lordship, the petitioners are working in different capacities in the code, fast-track codes like drivers, stenographers, and etc. Lordship, by a review petition number 82 of 2013, Lordship, the Honorable Court had at 151 is the effective part, Lord. Page 151. Page paragraph 5. A review petition was filed before this Honorable Court, Lordship, by the petitioners, and in the terms of the offer of settlement from the state government, the service of the petitioner would not be dispensed till they attain the age of superannuation and would be paid minimum wages or regular pay scales from March 2007 onwards. The Lordship, thereafter, Lordship, we were not receiving the allowances with the minimum wages. So that's why, and we were not, and for with regard to pension, the Honorable Court has granted us to give a representation before the department. We gave a representation and that was set aside. So we came before the single judge, seeking for two prayers. First is that we should be granted allowance as per the review petition as directed by this Honorable Court, and we should be taken under pensionable service or under section 151 of the pension code. Lordship, but however, both the prayers were rejected. Lordship, the Supreme Court in Jagjit Singh, Lordship, 2017, 1 SSC, 148, had clearly stated that temporary employees or the contingent employees, everyone would be getting the minimum scale of the regular pay scale. And even this,
there is a later judgment also.
Lordship, even this Honorable High Court on the state of Assam, Upendra has also held the same. So Lordship, our only limited prayer is that we should be getting our allowances, because when you are giving us the minimum wages with the and you are stopping our allowances, so Lordship, that is our prayer, Lordship.
No, but how your appointment is contractual?
It is, Lordship, but Lordship, that is why we have been but Lordship, there's a review petition that we filed before this Honorable Court, and by that review, but Lordship, may at page 68, Lordship.
Because your entry is not as per the recruitment rules.
Lordship,
your entry in service is not as per the recruitment rules.
No, Lordship, our entry is per the, but we were taken as a contingent employee, Lordship. That is why, for the effect of it.
No, how were you selected?
By selection process, by interview and by selection order.
Oh. Yes, tell us.
Well, page 71, Lordship. Page 68 is a review petition, 82 of 2013. And at page 70, Lordship, at the last part, and on 16/12/2016, for the amicable settlement of their dispute, the learned senior advocate, additional advocate general made the following offer, that the service will not be dispensed with till they attain the age of superannuation, that they will be paid wages minimum of the regular pay scale, and that that at the time of superannuation, they'll be bought under the medical insurance scheme. The learned senior counsel appearing of the above named 8 petitioners have agreed to condition number 1 and 2 for the offer of settlement. We therefore, having regard to the acceptance of condition number 1 and 2 of the offer of settlement, direct the state government as under the service of the 8 petitioner mentioned above will not be dispensed with but for discipline record by the state government till they attain the age of superannuation, and that they will pay minimum wages of regular pay scale from March 2017 onward. So Lordship, here it is where we have been not been getting the allowances with the minimum wages of regular pay scale, Lordship.
Now,
That is admissible allowances, Lordship.
now we view it from a little different angle.
Lordship,
Now, a person gets regular pay scale.
Lordship.
In the initial stage, he gets the minimum out.
Yes, Lordship.
Is he being paid allowances?
Lordship, he has been paid allowances. Lordship, in fact, this point is itself is cleared by the division bench judgment of this honorable court, Lordship. Lordship, I have given a copy of it.
Who appears for the government?
Not connected. What if in this case, what if two issues involved? What if whether a contractual or casual employee is
No, but you have agreed before the division bench.
not?
You have agreed before the division bench.
Yes, Lordship, we
To pay
agreed
them minimum regular pay scale.
minimum of the pay scale.
Of the
Lordship,
pay scale.
that is the phrase used in the Jagjit Singh judgment, Lordship, minimum of the pay scale. And in Jagjit Singh, Lordship, it has been clearly held that though they are entitled to minimum of the pay scale, they are not entitled to any allowance. Now, the question will come, Lordship,
You put it to the government if any way can be found out. Because you have agreed earlier. And
that minimum of the pay scale, Lordship.
Mr. Counsel, I can read that much English. Don't worry about it. When you earlier tried to test out something, if anything further is possible, explore the possibility.
No.
Otherwise, we'll hear you.
Lordship, hearing is required, Lordship. And second is, Lordship, whether a casual employee is entitled to pension. These two issues are involved, Lordship.
That you will not be able to argue that.
Lordship, my problem today is, Lordship, only in the morning I came to know that this matter has been listed, Lordship, because my name is not appearing in the court list.
You appear for whom?
Finance department, Lordship, as well as for judicial department.
What you considered before the division bench?
No, that is the same judgment, Lordship, passed in the Upendra's judgment. The undertaking given by the state government in the Upendra's judgment, and in this case of same, Lordship.
No, may I just
There we gave undertaking only to give them minimum of the pay scale. Now, if we give them everything, Lordship, it will become equal to a regular government employee, Lordship.
no, Lordship, it won't be.
Only.
Lordship.
May I just read out, Lordship? Lordship may present the judgment. At para 22, this honorable court, a similar matter state of Upendra's, Lordship, it has been said.
No, you take us to the 64.
Page 64, Lordship.
Sorry, 68.
Yes, Lordship.
That is the review judgment you are referring to.
Lordship, that's a review judgment that's happened in my particular case.
And the penultimate directions are available in para 71.
Para 71, Lordship.
Page 71.
Yes, Lordship. Paid minimum wages or regular pay scale. And in fact, they were paying the wages, Lordship. They were paying the allowances also. And somehow they stopped without any order. Lordship, that
Initially we paid, Lordship, that we realized that we are wrongly paying.
So, but this order you have not sought for further review or telling.
Which one, Lordship?
This division bench order.
no, that was never challenged by the government.
We are paying in terms of the division bench judgment, Lordship.
That
Division bench judgment says you'll pay the
Minimum of the pay scale.
minimum wages or regular pay scale.
Minimum of the pay scale is the basic pay plus grade pay. I mean, minimum of the pay scale plus grade pay. That is the basic pay, Lord. That is the minimum of the pay scale that we are paying, Lordship. But he is claiming for allowances just like an ordinary regular government employee, Lord.
Lordship, the judge, may I just submit here, Lordship? Lordship allows me to. Lordship, it's a very much in the service jurisprudence scale, Lordship. A person who starts, he will get a scale, and the scale is all inclusive of allowances. And that point has been cleared by the state of Upendra's, Lordship, where it has clearly stated that we accordingly direct the state government to implement the measures, Lordship, at page para 22, Lordship. para 22, page 8, Lordship. We accordingly direct the state government to implement the measures without further delay. Besides this, we in the light of the Supreme Court in state of Punjab, as a Jagjit Singh, also direct the state government to pay minimum of the pay scale to the master role workers, work charge workers and similar placed employees working since more than last 10 years with effect from 1/8/2017, Lordship. So Lordship, what I'm only praying, Lordship, that minimum wages of the regular pay.
You are a contract worker.
Lordship, we were contract worker. We have been defined by the period of this review judgment that our term of contract would end at our superannuation. And by Upen Das and by Jagjit Singh had been stated that when the selection process is regular, then you would be getting the minimum scale or minimum which is the regular pay scale. So the scale would automatically include all the allowances. Lordship, I would like to submit. Lordship, when a scale comes, the scale is inclusive of all the DNS allowances.
Review against the judgment, seek clarification.
So Lordship, that is, we were getting it, Lordship. They stopped it and that's why a new cause of action arose. That's why we filed a writ petition. In fact, Lordship, in our writ petition, the second prayer has not even decided, Lordship.
When will you be ready?
Any day, Lordship, after 1 week, Lordship. Otherwise, I'm ready, Lordship. It will not take much time.
Whatever time it is.
After 28th,
Lordship, there is, before Lordship possible.
22nd?
Lordship, not on 23rd, Lord, 22nd.
You come on 28.
Lord.
I beg before your Lordship to submit one thing before Lordship passes over. Lordship, there's one more error with the single judge judgment, Lordship. He did not decide on the second issue with regard to the pension. There's nothing on work with, even we mentioned in the prayer, that whether with regard with our representation being before the pension department, whether we are pensionable or we not be
That is a different issue.
Lordship.
But even we can direct the state government to decide your representation if it is not.
Yes, because yes, Lordship. That is because Lordship, as per section 151 of the code, I will just place it for a glance, Lordship. I know Lordship is just for a glance.
We have a code. You are Mr. Das?
No, Mr. Sharma.
Mr. Sharma. There is a saying. If anybody gives you finger, don't try to.
I understand. No, Lordship, just for a.
Otherwise, everything will come down. If Uma Devi is applied, you all will be irrespective of their agreement. Don't
Lordship.
forget that.
Lordship.
Because this is more a sympathy jurisdiction which has been exercised by the division bench earlier.
Lordship.
Don't forget that.
Lordship.
A bird in hand is always worth two in a bush.
Lordship.
There are perils also. We are not threatening you. We are only making you aware.
Lordship.
We are aware that you are more aware than what we are.
No, Lordship.
Matter number 38.
May I please the Lordship? Lordship, here I'm appearing the conducting counsel, my lords, his father is unwell, my lord. Because of he could not appear. In this case, my lords, we have to file an affidavit, my lord. Lordship, I seek 2 weeks time, my lords. In the meantime, we'll file the affidavit and my learned counsel may appear.
Your affidavit must answer the question with regard to challenge of virus.
Virus.
Lordship.
5th of December.
Obliged.
File affidavit. Next. It at 2 o'clock.
It's the impugn order, the page number 71.
What is wrong in the order?
The grounds that we have taken, Lordship, it's in the ground we have specified certain aspect of the matter. The first aspect is that, Lordship, this the order that has been passed by the honorable single judge, that has not dealt with the contention that we have taken in our affidavit in opposition. Because there is no only the mere statement on the part of the petitioner or the respondent herein with regard to the fact that the demolition was done violating the order of the court. But the fact is that, Lordship, if there is any violation on the part of the GMD or the authority herein with regard to the order that has been passed by the learned trial court, and the proper procedure is the execution of the decree for violation of the civil court's order.
Say that you get a license to disobey the order of the trial court?
No, Lordship, only thing
Only
is that,
because you are an authority?
yes, only thing is that in the writ petition, only the specific averment was there on the
Naturally, it has been believed, rightly so.
because
The Water Act came in 2008, they were there before that. We can understand 50,000 which your officers are asked to pay, we can interfere. Otherwise, nothing. Restore them first and then argue. Otherwise, we will not permit you to argue or contention in this. What is this? You take law in your hands only because you are authority?
Lordship,
And you are throwing burden on GMC on GMDA? Because you learn a single
in
judge?
the writ petition also, Lordship, there is no clarity with regard to the fact which is the authority who is
Sir,
responsible.
counsel, more you argue, if we go deep
Yes,
into
yes.
the matter, your officers will go with one digit more. Let us be very fair and frank with you.
For the factual aspect, I'm just trying to emphasize on the factual aspect of the matter, Lord.
And don't tell higher court that you are not heard. It is absolutely a correct order. Except para 4, we can understand. At the most, we can interfere for the cost. Otherwise, nothing. Restore them first.
But the last order, Lordship, at page number 77, the deputy commissioner and the GMD should pay cost of rupees 50,000 each.
That we can
Yes,
be liberal and
Yes, Lord.
take a call on this. Otherwise, nothing. See, these are all admitted positions. 2008, the Water Act has come.
Yes, Lord.
Then they were in existence, their decree is there, and you argue that it has to be executed. You have not left anything to be executed. Reconstruct it first. Otherwise, this amounts to contempt because 3 years have passed. What have you done for 3 years? This order is of 27/3/2019.
Because here in this case, Lordship, this the order passed by the almost single bench. With regard to the directing the deputy commissioner, the GMD shall put the two petitioners back in possession over the
Naturally.
declared land.
That you
Assessment
have to
shall be
do it.
made. I will get the instruction with regard to that, Lord.
No, we don't know. We are not dependent on your instructions. Implement the order. 3 years have passed, otherwise we will issue contempt notice against them. This is a continuous contempt. Nobody is safe with this bureaucratic approach.
Interim order.
There is
No,
no interim order.
there is
You,
no.
you yourself grant stay to yourself. We don't know, the concerned deputy commissioner might have been transferred somewhere.
Yes, no. And Lordship, kindly give me a 1 week time, Lordship. In the
This
mean,
petition is filed at their instance. This
Yes.
appeal itself.
yes, no. Lordship, kindly give me a week's time. So in the meantime, I will get the
Next
necessary
week,
instruction.
nothing doing. Next Thursday. Next.
Number 26.
That's all. Affidavit was to आगे.
In fact, of purpose of a court order, मतलब I have filed a affidavit, मतलब.
Affidavit has come. Let us go through it.
Page 70, turning page number.
The inability to pay has nothing to do with element.
मतलब
These are not surface proceedings. Otherwise, Mr. Sharma would have appeared.
I have to मतलब
Inability to pay is nothing to do with your permanent element. 5 or still
2 lakh shares permanent with 8 installment, मतलब.
Sir, 2 lakh means 6% interest
मतलब.
maximum that anybody can now get. 6%.
मतलब.
So what does it come to? 1,000 per month.
मतलब.
What is the value of 1,000? In 2022. Only because it is a first appeal, it is not that every first appeal has to be admitted. We can call for the record and proceedings and dismiss. So the LTR is already,
Not challenging the divorce, my lord, but
we know
testimony
that
is much
government
accepted.
disability has nothing to do with it. We can, now you go to the order.
So I have received 42,000 per month, my lord. I have to procure my family, my lord, including my old age mother.
If you would have been staying together as wife, what would be the position of your 42,000?
My lord, I admit it, my lord.
Then,
But at one time, my lord, I am very difficult to pay the amount, my lord.
we'll give you installment. Go to the order, impugn order.
Impugn order, my lord, kindly see, my lord. Page 69, my lord.
Yes.
In a result petition filed by the plaintiff under section 120, the marriage solemnized between the plaintiff Kobita Das Bormon and defendant Bituraj Bormon is dissolved forthwith. The appellant defendant will accordingly pay rupees 6 lakh only to the plaintiff as permanent and future alimony for her. The defendant also directed to pay rupees 10,000 to the plaintiff as cost of the proceeding.
At the most, we can give you some installment. Nothing more.
My lord.
18/4 installment. Deposit 1,50,000 first. Then we'll pass that all.
My lord.
2 weeks.
But it is difficult, my lord, 2 weeks, my lord.
Then how much time do you want?
1 month, my lord, within 1 month. I have no property to sell, my lord.
You deposit 1,50,000 in the registry by 5th of December.
My lord.
Notice only for the limited purpose of granting granting in 4 installments to pay 6 lakh, which is granted as permanent alimony. To be respondent be served additionally by registered post-study as well as the service. On condition that the appellant shall deposit the sum of rupees 1,60,000 with the registry. Latest by 3rd of December 2022. Next.
Number 27.
Yes,
I have taken instruction in this case also from my side. My client has been released from the jail.
So far this detention order goes, there is no question of keeping him inside by virtue of this detention order. Because this
we'll say if not required in any other matter.
If not, look.
That is why we decline the.
Yes, yes. This can be closed because this detention order is no longer in.
Detention order is now no more there.
No more there.
We are knowing that, therefore we insisted.
Yes.
This petition criminal number 36 of 2022. Mr. P.P. Datta, counsel appearing for the petitioner, on instruction states that the impugned order of detention dated from has been revoked. Has been revoked.
This has been.
I have been released from jail.
It states that during the pendency of this petition, the petitioner has been released on bail. The petition therefore does not survive. What is discharge? Next.
Number 36.
I'm sorry, my lord, on first call I couldn't appear, my lord.
Where is Majmudar?
Right, it is covered,
My lord,
it's not covered by the earlier judgment.
Majmudar,
No,
what
my lord.
happened?
because my lord, earlier judgment,
I hit my knee, my lord.
Huh?
I hit my knee on the table, like. My knee on the table, my lord.
Take care.
Look.
We want to have water or something.
No, my lord. Just hit my left knee on the table.
the earlier judgments perhaps my lord will help the petitioner, my lord, in this case. Because my lord, in the earlier judgment, if lordships come to the compilation, my lord, I have given page 37. Paragraph 20 of Kripa Sindhu's case, my lord.
Page number?
Page number 37 of the compilation, my lord.
There is no page 37. That is the difficult.
My lord, in this compilation, my lord,
There is no page 37. We have page 30, 32 and then directly 42. Oh. It is not properly bind. We'll find out. 37. Yes, read in another cadre.
my lord. Paragraph 20, my lord. As it could be seen from the provision of Rule 3 of the 2003 rules, the service of provincialized schools consists of teaching staff of the non-teaching and the non-teaching staff. The teaching staff of the in the service are classified into two classes, that is class 2 senior and class 2 junior. Each class consists of a number of distinct and separate cadres. Class 2 senior comprises of the cadre of principal, vice principal, postgraduate teacher, and headmaster superintendent. As per the rule 2003, all these four cadres are distinct and separate cadres. The post of principal, vice principal, and postgraduate teacher are in the teaching staff of the higher secondary and multipurpose school, and thus the conditions of service related to the school's post, though in service, are not related to the high school. Only the post in the cadre of headmaster within class 2 senior in the service is in the teaching staff of the high schools. The class 2 junior consists of 8 distinct and separate cadres. Out of these 8 cadres, one of the cadres is that of assistant headmaster. In another cadre, class 2 junior, A, graduate teacher, B, Hindi teacher, having bachelor degree from a recognized university, and the classical teacher, Sanskrit Arabic language teacher, having bachelor degree from any recognized university, are clubbed together. Thus, as per Rule 3, the cadres of assistant headmaster and graduate teacher are two distinct and separate cadres. So, my lord, both these cadres in the earlier judgment, my lord, this honorable court held that these are two distinct and different cadres. Only because, my lord, earlier in the 2003 rules, the promotion was made on the basis of school-wise seniority, and if the assistant headmaster is given preference, there will be no element of selection. On that ground only, my lord, in the earlier round of my lord, litigation was negated. Now, my lord, the situation has changed. Under the 2018 rules, the promotion is made on the basis of district-wise seniority, not on the basis of school-wise seniority. So, my lord, if the district-wise amalgamated seniority list is, my lord, considered, then, my lord, perhaps, my lord, the scope of, my lord, selection will be there.
You have dealt with in your written argument.
Yes, my lord.
There are 40.
14.
40.
40. Yes, my lord. Having considered the issue, my lord. Having considered the issue from the point of view of reasonable classification and in the light of the discussions made above in respect of the facts of the attending to the instant case, the impugn provision of 2003 rules, we are of the considered opinion that the impugn provision do not offend the equality clause so as to violate any of the fundamental rights contained in Part 3 of the Constitution of India by making the provisions of counting the seniority of the prospective candidates on the basis of their seniority in the cadre of graduate teacher in a provincialized high school for the purpose of promotion to the single post cadre of headmaster in the high school in 2003 rules. It cannot be said that the hostile discriminatory treatment has been meted out to the members in the service occupying the lone post of cadre assistant headmaster, if any, in such high school wherever such post exists in the teaching staff of the particular high school. It cannot be said that the framers of the rule did not take into account the relevant consideration and took relevant consideration into the whole. By such provision, no fundamental rights of any member in the service to be considered for promotion to the single post of assistant, single post of headmaster in a high school has been extinguished. What has been affected for the member of the service occupying the lone post in a single post cadre of assistant headmaster are the chances of promotion, which is not a fundamental right. We are of the considered view that overall effects and workability of the impugned provision have not resulted into any kind of unfairness, arbitrariness, irrationality to an incumbent in the cadre of assistant headmaster in the service. On the other hand, the larger pool of eligible candidates is available for the purpose of promotion in the service in view of the impugned provision, who all are to be considered in terms of the criteria for promotion laid down in the rules 2003.
Now, what is the change brought in the 2018?
18 rules, my lord, the consideration is to be made on the district of seniority
For the post of
headmaster. Earlier, my lord, it was confined to the school-wise seniority.
that seniority, how is the seniority determined in your case?
My lord, in our case, my lord, we have been clubbed with a graduate teacher.
That seniority will go back 2014, the day of receiving the graduate scale
My lord.
for everybody in the district.
Yes, my lord.
So how does it affect?
Because I am in a different cadre altogether, my lord.
That has been clarified by the judge.
My lord, in this judgment, my lord, though in paragraph 20, this honorable court held that they belong to two distinct cadre. My lord, on the facts and circumstances that if school seniority is not,
If judgment was the effect that you belong to distinct cadre, but this seniority being identified or determined in respect of the candidate with the rule 24 will not affect your chances as a for selection
Yes.
in post of headmaster.
that is true, my lord, that is true. But my lord,
You wanted to say was that since assistant headmaster was a separate cadre,
yes, my lord,
your seniority cannot be clubbed with the graduate.
graduate teacher.
Your seniority has to be done separate.
Separate.
That has been rejected by this.
My lord, because of the fact that my lord, earlier, my lord, the promotion was made on the basis of school seniority, and there is no scope.
School or district, the seniority would remain the same.
No, my lord.
From
If-
one school, there will be only one.
One,
assistant.
one,
Yes, my lord, that is why, my lord. So, my lord, question of seniority will not come in. If it is done in the school-wise seniority, then only one teacher will be there as is the headmaster, my lord. There will be no
Sir,
competitor.
counsel, even if it is done say school wide, then also if somebody is senior to you in other school, then he will have priority over you.
No, my lord.
Then
The other persons from,
that is what brother is trying to explain you. What difference does it make?
my lord, what I'm submitting, my lord, earlier, in the earlier rule, 2003, as the lone post of assistant headmaster was there in a particular school, and as the school of seniority was considered, so, my lord, there was no element of selection. There is no element of selection. Only the assistant headmaster will become the headmaster. Now, my lord, as the situation has changed, and the seniority has been determined on the basis of district of seniority, and amongst in the district, my lord, the assistant headmasters of all the schools, my lord. They will be clubbed together, my lord. Their seniority will be considered.
Lordship will kindly have of the same judgment. This has been answered by this honorable court, madam. At para 32 of the judgment he was referring to.
Let us first understand what he's trying, how he's
And-
trying to interpret the.
Yes.
It says that he was the new group. There which he selected is to be made in terms of district-wide seniority.
Very correct.
So this district-wide seniority, it first has, will have to be drawn from each different
Assistant headmaster.
and then it will have to relate back to the section 24.
Yes. And take up all the graduate teachers. But there are two types of high schools in the state of Assam. One which is 2 class and one which is 5 class. 2 class schools do not have assistant headmasters at all. So therefore, if in a 2 class school, the graduate teacher serving in the 2 class school will never be able to participate for the post of headmaster in another school in case we allow only assistant headmasters of that district to participate for the post of headmasters. That has also been kept in view by the department.
My argument
In
is
those
not that-
cases where only 2 classes will remain in a particular school, there are 15 teachers of graduate school of pay who are senior, in fact, to the assistant teacher serving in some other school. This graduate teacher will never be able to compete because if we restrict it only to the assistant headmaster, we will be taking away all chances of promotion of these persons who were not posted to the school because of their choice. We posted them there because it was the government's prerogative to post them there, but we cannot take away their chance of promotion totally. That is one aspect of the matter.
Typically, but we
Therefore-
wanted to hear you. How would you like to distinguish your case from the earlier
Yes.
decided case? That's all.
My lord, that is.
And
my
his
lord,
argument
my-
has been
what I
discussed at
have said-
paragraph.
What you have submitted so far has already been answered. It is
It is answered. That is-
my lord, I am not saying that only the assistant headmaster should be considered.
Sir, Mashmudar, the post of assistant headmaster is a promotional post
Yes.
from.
It is a senior most teacher in a particular school.
by way of order or nomenclature.
By the promotion, my
Promotion. In the rules, it is called a promotion.
No, but promotion from which post? Graduate?
Graduate teachers. The senior most teacher with the
Now with view of the change.
Yes.
It higher schools are these 5 plus also included.
Yes, they're both high schools. They're both high schools, but while 5 class schools have at the post of the assistant headmaster, 2 class schools do not have that post.
The 2 plus schools are also included.
Yes. So these graduate teachers will also compete for every post of headmaster, which arises in the district. Otherwise, these people will never have a chance to apply for any post of the, they'll never be able to compete for the post of headmaster because they do not have the post of assistant headmaster. And that was one of the reasons given in the judgment itself, showing that in that particular school, there'll be no other candidate to participate. Here in the district, from a particular schools, the 2 class school teachers will never be able to participate. They will be taking away all their rights. They will not have the post for.
Yes, sir, starting on it.
My lord.
Post of assistant headmaster is a promotional post.
Yes.
Now, for example, if five class school as a assistant headmaster.
My lord.
So earlier you would be a graduate teacher,
Yes.
and from 2 class school, a graduate teacher also will become headmaster
Yes.
on grounds of seniority.
Yes.
In this five plus,
My lord,
where there is a post of assistant headmaster,
my lord.
is the only the assistant headmaster is considered for graduate teachers?
Graduate teachers are also considered from that school also.
All,
Yes, all.
because it is, see, their Sangam is section 24.
My lord,
As far as their seniority is concerned,
it will be section 24.
it is 24 which comes into play.
My lord,
That is what we wanted to,
24 comes into play, they will all be considered, their
Equal.
seniority will be considered on the graduate scale.
will anything else that you want?
You are hurting on the fact that court has held that these are two different. My lord. Nothing wrong about it. But one more aspect, my lord, one more aspect. I am holding a my lord, promotional post from that of the graduate teacher. Now, my lord, if both the posts are clubbed together, my lord. No, they are not clubbed together. It is only the seniority determined. Yes, my lord. For the purpose of my lord, promotion, they have clubbed us together with the graduate
No, but
teacher.
see, Ansel, if you are a assistant headmaster, then naturally you would be senior in your cater of graduate teacher also.
No, I may not senior also, my lord, because my lord, some persons
Huh.
who doesn't have the qualification of BA, they could
And
not.
that is a different aspect.
My lord.
Now, only one aspect which I want your assistance. These 6 judgments which you are relying upon,
My lord.
please give the paragraph number.
My lord. Lord, I have mentioned the paragraph numbers, my lord, in the index, my lord.
So no other paragraphs are you are relying upon. It is there in the index. I stand
My lord.
corrected. Heard. Done a council. That is for order. We'll base your written arguments as the.
My case is that my lord, they can give some preference to the assistant headmaster, my lord, for the purpose of selection.
You have stated so in this.
Yes, my lord.
I will consider.
My lord.
The basis of arguments of both the sides would be the written argument.
My lord.
Obliged.
Item number 39.
Yes, Mr. Nath.
But here my instruction is, Lord, the financial sanction thing is before the departmental minister, Lord. He is the honorable chief minister of the state. But now the matter is with him, Lord. We are expecting, Lord, within a day or two, it will come.
Tell us on Monday.
We'll tell. Definitely. We'll inform on.
14. At the request of Mr. T. Nath. And Mr. Das.
My lord.
In one matter, we had appointed you as amicus.
Yes, I'm sorry, my lord,
No,
in morning hours.
You are not at fault. Your name was not reflected.
Yes.
We have passed that order.
Lordship.
That also probably we have kept it on 14.
15, I think. My lord.
15.
15, yes, my lord.
15.
I'll be there to assist, my lord.